Hi, everyone. Thank you for joining us. I am Shanna Tara O'Toole, the founder and director of the Clause 40 Foundation and the Due Process Institute. The Due Process Institute is a 501c4. We essentially think of ourselves as lobbyists for the Constitution, and we focus exclusively on trying to improve the criminal legal system. Clause 40 Foundation is our sister C3. Like all of you, I am frightened about what's going on. I fear for the lives and safety of those who are incarcerated and for those who might still be. I worry about the ever-increasing due process challenges to the people who are, as of yet, accused of crimes or have been accused of crimes and are waiting to defend themselves. And I thought that it would be a good opportunity to bring us all together to share our questions, share our concerns, and maybe, hopefully, share some answers. I am joined today by some truly talented and unique people, and I so appreciate them giving us our time, and I'd like to introduce them right now. First, I'd like to introduce April Frazier Camara. April is the Chief of Lifelong Learning at National Legal Aid and Defender Association, where she leads in-person and virtual training for the defender, civil, and client communities. While at NLADA, April co-founded the Black Public Defender Association in 2018, which is a national network of skilled Black defenders aimed at improving the quality of defense provided to low-income communities. Prior to joining NLADA, April worked for 8 years as a public defender with the Public Defender Service for DC and the Shelby County Public Defender Office in Tennessee. She is the incoming chair of the American Bar Association's Criminal Justice Section and a graduate of Howard Law School. We're also joined by Brett Tolman. Brett Tolman served as a federal prosecutor for nearly a decade. In 2006, he was appointed by President George Bush to be the United States Attorney for the District of Utah, a position he held for almost 4 years. Since then, he has practiced as a criminal defense attorney and recently founded the Tolman Group, which focuses on public policy and government reform. In fact, Brett has spent quite a number of the last couple of years here in Washington, helping make federal criminal justice reform a reality. We're very proud of that work. We're happy to have partnered with him on some of it, and we are very proud to have currently count him as a member of the board of directors for Clause 40 Foundation. Thank you for joining us, Brett. We also have Premal Dharia, who is the founder and director of the Defender Impact Initiative. Premal spent nearly 15 years as a public defender in 3 different places: the Public Defender Service in Washington, D.C., the Office of the Federal Public Defender in Baltimore, Maryland, and the Military Commission at Guantanamo Bay, Cuba. She also previously served as the Director of Litigation for the Civil Rights Corps, where she oversaw national litigation and advocacy efforts aimed at changing the criminal system. Somil Trivedi is a senior staff attorney at the ACLU's Criminal Law Reform Project and a good friend of mine. He was previously a federal prosecutor and a defense attorney and is currently part of the ACLU's strategic COVID response team that is litigating and advocating for release of criminal and immigration detainees nationwide. And last, we are joined by Timothy O'Toole. Tim is the lead of Miller & Chevalier's White Collar Defense Practice Group and is a co-host of a terrifically informative and actually entertaining podcast called Embargoed, with a exclamation point, which covers the fascinating world of sanctions, export controls, and all things international trade related. So if you are looking for something to do on these quiet days, there's a podcast recommendation for you. Prior to private practice, Tim served as the chief of the Special Litigation Division of the Public Defender Service in DC and as an assistant federal public defender in Las Vegas, Nevada, where he handled matters for people under sentence of death. We are very lucky to have him serving on the boards of both Due Process Institute and Clause 40 Foundation. And I guess that's what I get to inscript him in as my husband. So, thank you, Tim, for saying yes to that. I've also asked Tim to serve as the moderator of this webinar because we are self-quarantining together, but also because he knows a lot of what he's talking about. And we are hoping to make this conversation as lively as possible, as much of a conversation as possible, given our technological limitations and given the fact that we are being joined by nearly 400 registrants for this webinar and wanting to make that actually work for everyone.
The consequences of incarceration have gotten dramatically more serious right now than they were a month ago, both for our clients and for society, because as I understand it, not only are the folks in the detention center obviously in a small confined space where you're not going to be able to practice social distancing, but once once the epidemic comes into the jails, there are people working in the jails who are going to work with people and take it out. And so I guess, I'll throw the question over to you, Somil, and to you, April. Are you seeing this make a difference in detention decisions? April, I know that you've done a lot of work in the parole context, in parole decisions. Like, how are courts viewing incarceration now? And how are prosecutors, to get to Brett's point, viewing incarceration now compared to how they were? Are they kind of viewing it as a new ballgame, or are they viewing it kind of the way they did 30 days ago?
Yeah, so thanks, Tim. I think an important point when we talk about attorney-client relationship, to remember the clients that's at the back end of the system. So people who may be held for probation and parole violations. And fortunately in DC, I saw some good news about holding people pre-probable cause hearings with the U.S. Parole Commission. And I think it was some leeway there in allowing those people to be released and to come back and have a parole hearing at a later date. But it's a lot of people who are still being held, and those decisions are not being made by judges. Those are parole commissions and other systems that's on the back end who are also making decisions about liberty. So I really, I think it's important for us to keep track of all of the different entities who play a role in the decision-making process for people who are sentenced. So I know we talk a lot about pretrial and being able to represent people on the front end, but I think the back end is very important for us to pay attention to as well. And then I know, incarceration takes many forms, right? So of course, incarceration in an institution, but also people who are under parole supervision. So for me, when I was at PDS, we did early termination of parole hearings. What about people who are on what we call in DC paper, who are still under the supervision, and they may be legally entitled to come off of parole? All of those rights are also being infringed at this time as we see a delay in giving people due process to exit the system on the back end as well.
Yeah, and I'll echo April's concern about the back end. It's supremely important, but on the front end, to your question about whether we're seeing prosecutors take the necessary actions to prevent the inflow of folks into what we know are petri dishes and breeding grounds in the jails, I would say on the whole, no. The sort of usual suspects of reform prosecutors here and there around the country have sort of upped their commitments to cite and release or stop charging certain categories of crimes, and that's always welcome. Frankly, it's something that should have been done already and was already being done in those jurisdictions already, and we appreciate that. But this is a whole different ballgame, as you've said. And so it's going to take, in my opinion, a wholesale reconsideration of charging, screening, diversion, plea bargaining tactics, with the ultimate goal of not creating additional vectors for the disease. And thus far, I have not seen robust enough plans, even from reformers on the police or prosecutor front. I mean, I'll just take one more point with respect to the attorney-client privilege. Obviously, the frontline folks, public defenders and others who are dealing with clients today, they're in the most dire situation. But I will say, I know we're going to talk about, efforts to release folks from prison and systemic efforts to do so. And, the ACLU and many other organizations around the country are trying to do that right now. And it's nearly impossible for us to find clients as well, to find class representatives, because we're so dependent on public defenders to have access. And so we're having to dig up doctrines like next friend status, which Premal knows, we sort of last used in the Guantanamo context, and we don't often pull out every day. And so, speaking of a totally new landscape, that's just one example of how things have changed in the last literally 3 weeks.
Yeah, and Premal, what do we, you talked about the attorney-client relationship and all the different ways that it's been impeded on. Somil, you were just talking about the lack of access that public defenders currently have. I think April was talking a little bit about that too, in terms of meeting with clients. What do we do about that? I mean, I know that one solution that has been put out there is this increased use of, what we're using now, these sorts of virtual conversations. what are some of the problems with that? And is that any sort of solution to this? Is that going to help at all?
Yeah, I mean, I think sort of as a preface to what some of the solutions might be, identifying what the underlying problem is feels really important. Of course, there's the issue of not being able to build trust and build the relationship, but the urgency that that is needed for is to be able to secure or to vindicate whatever you need to vindicate in the court process. And that might be through resolution of your case, through a trial or some other means, but it also might be seeking release from the detention facility or the jail, right? And so it's the urgency of those things that necessitates the sort of pushing of the attorney-client relationship to be able to develop. If someone is released and there is sort of less urgency to seek vindication in the courts, then it makes it easier to relax some of the need to push forward with building the trust and building the rapport and getting the things done, reviewing the documents, reviewing the evidence, making decisions together. Those things can become less urgent and can sort of take their time as the pandemic unfolds. But given the reality that people are still incarcerated and seeking those things, what courts have come up with so far that I'm seeing in some places spans a spectrum from continuing to have in-person visitation, which of course is some people may opt for that, and so maybe that's the right thing to do in some cases. It also presents lots of health risks, of course. In other places, there are only phone calls available. And some of the issues that we see with that are that, many jails, particularly when we're talking about rural places, small county jails, places where there's not much of an infrastructure, there might be 2 phones, right? There's not a lot of options. And then people are also using those same phones for their family and friends to be able to reach them or to reach out to them. And so there's an overburdening and a lack of availability of the kind of constant contact one might need to have with counsel. And then some places have started to implement video, which certainly, as it compares to phone, is a better option because you can at least see each other and have some of that body language and sort of, gestures, but it doesn't address any of the actual concerns about being able to look at documents together or sign papers together or build the rapport. And with all of these non-in-person options, there is a real threat of a violation of the confidentiality that is essential for an attorney-client relationship to be able to thrive.
So it's like you knew our first question. So we just got a question from Missouri. And my understanding is that they have stopped in-person visits, that it's only phone, only Windows, so they apparently don't have video conferences. And the question is what can we do about that? But I think before we get to that, I did want to turn back to Brett very quickly. It sounded from his comments that he's still able to visit with his clients on some regular basis. I mean, how are things in Utah in terms of client visitation and the ability to do that? Were your clients out already?
Yeah, no, visitation is limited, and most of my clients are federal defendants, and they're all over the country. I have cases, East Coast to West Coast, and so where in fact, I had to cancel 2 trips where I was going to have in-person meetings with clients, and I'm very concerned. I know it's on a local and state level as well as on a federal level, but I don't think you can be an adequate defense attorney not having in-person meetings. I don't trust that the attorney-client privilege is going to be kept, sacred as it is and needs to be. And I don't think, think about some of the defendants that we all have had and how, without an ability to read their nonverbal cues, to read how they're, taking in what your discussion is, you're not an adequate attorney. I can't do it by phone. Video conferences is good, but it's so limited if they're incarcerated. And so I have real concerns that what we have is just mounting and building challenges to a fair process for these defendants. And I get why we're doing it. I get that we have such an urgent and an emergency scenario, but I am particularly, worried that it's already tough enough as a defense attorney. We see how the system is, you're not presumed innocent. You are presumed guilty, and you have to overcome that challenge. And Tim, I thought I was the greatest attorney in the world, and then I stopped being a prosecutor. You win
a whole new job, isn't it, Brett?
Right, it's a whole new job, and yet I like this more because I'm fighting for what seems like, to many, inconsequential issues, but to that very person, it's life or death, and literally it feels that way. And so I'm real concerned without the ability to have in-person communications. I think it's a bigger issue than people think it is.
Right. And Tim, I just wanted to weigh in because I think Brett raises a really good point. And I just want to highlight, like, people are still on death row. Like, this system is actually killing people. And so when we talk about life or death, it really truly is life or death. For me, a family friend, Purvis Payne, in the state of Tennessee, has a death sentence of December 2020. What does it mean for people that's on death row when investigators cannot go out and investigate and do the mitigation work and launch the campaigns for clemency? What does it mean for those people? And I'm very concerned. While we may be seeing some jurisdictions who may have progressive prosecutors and doing system-wide things like New Jersey and releasing people, I'm more concerned about the systems who may take this opportunity to kind of speed up the process of death sentences and other things that the attorneys will not have the ability to fight back against. So I want us to really pay attention to the dark places, because there's a lot of dark places out there who may use this as an opportunity to do more harm.
Yeah, I mean, I think, I did want to get into that, April, about the sensible prosecutors who, at least, it might not be the right thing, and we can talk about that later in terms of speedy trials, but when you put cases on hold, at least the case doesn't get worse. In a capital case, if you're not putting the case on hold and you're trying to move it, then you've got to actually litigate things in this climate. And I can't imagine what it's like to represent a client sentenced to death in a post-conviction proceeding with a live execution date, with a live warrant, and actually have to engage in the, sorts of conversations that we're talking about here, and really find out information and run an investigation while, this outbreak is going on. I mean, in terms of the cases that's under warrant, you mentioned one in Tennessee. What's the attorney-client relationship like there? Are they having access to the client? Are they able to talk to him? Is he able to kind of understand what's going on in his proceeding?
Right. And I think, we talk about the attorney-client relationship, but what about tracking down witnesses? What about exploring evidence of innocence, trying to get access to information in a system that in many places are shut down, even being able to get into a forensic lab to get access to something to re-explore it? All of those issues. Yes, it's about getting access to the clients, but also access to the evidence and witnesses.
I think, having done a few capital investigations in my time, the inability to do it live would be impossible. I mean, I'd sit outside and wait for people to come out of their doors and talk to them on their doorsteps, and they couldn't make me go away. But if they had the ability to just hang up on me, I'm not sure I'd have ever found out anything about those cases. And we got a lot of good stuff during the investigation, but it's really impossible to do that without doing it in person.
And I also think, one of the themes of today's webinar is going to be things that are sticky and persistent beyond the COVID crisis, right? And I think one of the questions is going to be investigation, even when you can get back in front of people, right? Issues like coercive plea bargaining exist because we don't have a regime where defense attorneys are able to properly investigate their cases. And now the ratchet is turned even more. And so I think what this crisis should do is cause us to reevaluate all of those things that were, as Brett mentioned, was already difficult and is now more difficult. And I think the inability of defense attorneys to investigate their cases, even under normal circumstances, ought to get a second look now. Short of speedy trial issues and other issues of that nature, I think we need to think about extending ability, extending time, extending resources to defenders so that they can do those investigations. And this crisis is shining a light on that problem, which is a silver lining, I think.
Yeah, although you raised one point that really scares me, which is, you know, does this become the new normal? So once, if you have to go investigate under a warrant and you do your best because you're not going to you're not going to sabotage the investigation and say, well, I'm just not going to investigate because I can't do enough. The courts are going to force you on pain of an execution to do it. You'll investigate. And so you do it by phone, you do it by Zoom, and you come up with some information, not nearly as much as you would have. And the next time around, the courts say, well, you were able to investigate last time without traveling to the location, so we're not going to pay for it this time. I mean, yeah. Brett, do you think that's a serious problem in terms of judicial resources?
Yes, I do. And if I had my magic wand right now, I would wave it. And what would happen is prosecutors would stop bringing stupid, bad cases and small, insignificant cases. And if you want to issue a fine, great. Legislators would cooperate and decriminalize, or they would, you know, mitigate penalties, and we'd get off of our addiction to punish. And then we would allow for sufficient time on those cases that are very serious, and we would function as a society having better educated ourselves and maybe reprioritize because of this crisis. But here's what I actually think is going to happen, and that's because I've been there, and I've, like all of you, we've seen it. There is a group in the criminal justice system that cannot be trusted to make good decisions without oversight. And that group is the prosecutors across this country. I can't emphasize enough that they have had unchecked power for so long that it is almost impossible to make an immediate pivot, as is now required through the lens of COVID-19 and the dynamics we're now facing. That pivot is almost impossible for them because they have wielded so much power. I reached out to a prosecutor on a case and said, hey, can we dismiss this case, this criminal case against my friend who's a upstanding member of society, but his dog bit a mailman? Can we dismiss this case now? Or do we have to go and appear in court and risk jail time? His response was, nothing changes for us. Don't think that COVID-19 changes our mandate to have to prosecute crime. So I get that, but they're not on the verge of making an educated adjustment based on new priorities, in my opinion.
So back to the panel, what's it going to take? Like, what if not this, if not the fact that a misdemeanor sentence is now, you know, has a high likelihood, or at least a reasonable likelihood, of becoming a death sentence. A dog biting the mailman sentence could turn into a death sentence. If that doesn't cause prosecutors to reevaluate their charging decisions and what punishment means, what can we do about it? I mean, what are the alternatives, and how can we make that change? Why don't we start with Somil, since I know you're bringing some lawsuits about this?
Well, yeah. So, you know, scare them a bit. And so first and foremost, you know, I'd like to change incentives, but we first need to get everybody we possibly can out of jails and prisons, right? So I think first order of business, we've all seen the suits that are being filed around the country, really creative ones under state emergency statutes, habeas, 1983, whatever it takes, federal, state. Whatever it takes to get especially the most vulnerable populations, but really everybody's vulnerable. You know, this virus spreads asymptomatically, right? So there's no such thing as anybody who is less or more vulnerable to catching it. It's just whether you'll die or not after you get it. So in our view, everybody currently in a place that cannot socially distance, cannot provide hygiene, et cetera, is at risk, and that describes jails and prisons. So the first order of business is filing as many of these cases in as many places as we can, particularly the dark places that April mentioned that are not gonna, where, you know, advocacy to the governor or advocacy to a single prosecutor here and there is not gonna cut it. We need sort of systemic change. And I hope that folks on this call have seen lawyers rise to the occasion, led by public defenders, to file these. So, and I'll mention, we're usually talking about these cases in terms of the Eighth Amendment, right? Cruel and unusual conditions of confinement. But for those who are in pretrial, that's actually a due process issue. So I hope off screen, Shanna is clapping somewhere, because we're getting to take a deep dive into pretrial due process issues. But okay, so that's the immediate need, getting folks out so that we create as few vectors for the disease as possible. But second, I think there is a colorable argument that prosecutors who make a charging decision that will result in confinement, as opposed to another decision that wouldn't, are being deliberately indifferent to the substantial risk of severe bodily harm, right? And that's an actionable legal decision that they're making that ought to be challenged in court. And I think for prosecutors who are wink, wink, nudge, nudge, threatening folks to take pleas because you don't want to end up in NDC right about now, do you? I think that is an actionable due process violation as prosecutorial vindictiveness. And so whether it's individual defense attorneys making those claims or folks like us and others making them systemically, I think for that, outside the small handful of reform prosecutors who are doing it on their own, I think they're going to need lawsuits and advocacy to change. And there are just some examples. I'd be very happy to hear others from those on the call.
Yeah, I was going to turn to you, Premal. I mean, April mentioned that there are some sensible prosecutors out there who are redoing the calculus of incarceration in light of the changed circumstances. Are you seeing any other successes? I mean, have we gotten any judicial decisions or any gubernatorial pardons? What is the light at the end of the tunnel?
Yeah, I think these are great questions. I mean, I don't think we've seen nearly enough action or success. A lot of the efforts, I mean, as Somil said, have been spearheaded by public defenders who are, on the front lines with their clients, sort of one by one seeking release. And, now there are lawsuits, which is great. But I think we're also just going to need to move beyond the courtroom in lots of ways, right? Because of what Brett was talking about, because there's unchecked power, because a lot of oversight needs to happen, and because we need to recalibrate some of the ways that we're thinking about stuff, right? In April's comments earlier, one thing that came to me was I completely agree with everything you said, and I think that a lot of what's getting lost in this conversation is that this infection, this pandemic, is a community health issue, right? It of course, as Somil was saying, affects those most vulnerable and others because it's asymptomatic, but it also endangers the entire community because staff are coming in and out. There's sort of constant churn and movement, as we've talked about in many places in jails and prisons. So the staff are bringing it in and out. It goes into the community that way. But also, as people are increasingly talking about, the surge that's going to happen when there's an outbreak is going to debilitate medical infrastructures all over our country. So entire communities, of people who have potentially nothing to do with the criminal system in their town are going to be impacted because their medical systems are going to be overloaded. And so this is an issue that prosecutors and judges and every single community member should care about. So I think that sort of that narrative needs to be something that's emphasized, I think, more. And then in terms of other action beyond the heroic efforts of the lawyers who are on the front lines doing a lot of this work, are thinking about, what are some legislative or court rule fixes and it's sort of things like that. One thing that's occurred to me, and we've talked a little bit about this, is that lots of courts have shut down, right? They've issued standing orders. Lots of facilities have shut down. It's not safe. It's not safe to have people coming and going. And they've shut down a lot of the processes that impact criminal defendants, jury trials, hearings, all of the sort of things that people need in order to be able to vindicate their rights or to seek their own liberty. But they haven't also simultaneously shut down prosecutions being initiated or arrests of certain kinds, right? And it's partly, we're not thinking about this as a public safety matter in the way that we need to. We need to be thinking about what is a great risk right now in this moment to public safety, and what are all of the different pieces along the whole spectrum of the criminal process from arrest on that we can address to advance public safety and to mitigate harm.
Premal is, I think, spot on, because you think about before the disease, the pandemic, and where were we at? We were in a justice system that, in essence, was failing 70+% of the time, meaning, you know, the national recidivism rate is so high. Incarceration was supposed to be meant as a last resort of individuals that were threats to themselves or dangers to the community. And we've turned it into, you know, our demand for justice is virtually identical with the demand for retribution against the individual. And I'm sad in a lot of ways with what is happening, because I'll give you two quick examples. When I first became a federal prosecutor, I remember distinctly being told there were 3 distinct purposes for a prosecutor, and that was, you know, that justice required the punishment of the guilty, deterrence of others, but the third one nobody ever talks about is rehabilitation, and we've lost that side to it. Now you take the pandemic and you lay it over the top. I was working with a few senators in trying to get, you know, federal legislation passed in the stimulus package that would address the incarcerated and the potential for, you know, that powder keg to go off in our incarcerated populations. And it's disheartening that there was resistance to do that among, you know, senators. And the White House, I had hoped, would do an executive order. And I even helped organize a letter from 405 former prosecutors sent to the president to ask for him to use his clemency powers to get rid of the, you know, the overcrowding of the vulnerable populations in our prisons. Why are we not seeing, you know, these types of, you know, traction in these types of efforts is maybe the most disheartening thing that I've kind of endured over the last many years, because to me, it means we're losing our humanity.
Right. And
Go ahead, April.
Tim, I just wanted to weigh in. I think, you know, when we look at the long-term impact of this, I agree with Brett. I think it's a struggle for kind of the soul of America, because when we talk about the harm of incarceration, we have a live, visible threat with the coronavirus, and we still see that people are unwilling to dismantle this system. And when we talk about harm of incarceration, I hope we will get to a place where we can have difficult conversations about race, because we have to talk about the fact that these decisions not to release people and to save human lives is predicated on also the communities that's most directly impacted, which are not only low income communities, but brown and Black communities. And what value do we put on the lives of people who come from those communities? And so I think it's some very difficult conversations about incarceration. Yes, right now we have a visible threat of coronavirus, but I'm sure many of you who have been public defenders or worked in the system, we can see the harm that's being done to our clients every single day, even if it's not the threat of coronavirus, the impact, the trauma of incarceration. And they do bring it home to our communities. It's a cycle, a vicious cycle of harm being done to communities of color. And that harm from incarceration is one that we see even in this crisis, that the system, we're going to have to fight like hell to dismantle this obsession with punishment and incarceration.
It's a great point. And one of the things that I've been struck by is that separate from the prosecutors, I actually have thought that there are some sensible wardens who have come out and talked about the real crisis that is going on right now and how it's going to play out. And I think it's, to me anyway, I think in part it's because they've seen the system from the inside up close in a way that many prosecutors even haven't, and certainly many legislators haven't. And so they understand the real human burden that incarceration plays. I think also they understand how if we think that the civilian medical system is going to be overrun by this crisis, I can't even imagine the light that's going to be shown on the jails and prisons around the country, because the healthcare system in those places was a crime already. And now when you stack on top of it, what's going to happen if those places, and it's inevitable that they will, at least some of them, get hit by an epidemic that they can't control because they have no way of controlling it. I think it's not a coincidence that the wardens are speaking out now because they know what's next.
And just to give you a concrete example of that, just today or yesterday, DAs from around the state of New York put together what they think is a comprehensive plan to take care of healthcare inside the facilities, and essentially guaranteed that those who remain in will receive the necessary medical care they need. That is laughable. As you just said, they weren't even doing that before, and now our civilian medical system can't do it, but all of a sudden we have prosecutors guaranteeing that they can do it for folks on the inside. It's absurd.
Yeah, I have a client who was in a couple years ago and got some relatively, very uncomfortable but relatively minor disease in the way that the healthcare system in the federal prison system, and this was a prison that people I think would refer to if they knew which one it was as club fed. In the federal prison system, the treatment for this was to put him in the hole for a month, and figure that maybe it obviously made him much worse. But they were basically trying to isolate him and not treat him so that they could contain what they thought was potentially a contagious disease. I mean, if your treatment for this sort of thing is to put people in the hole, you know that is likely not going to be a good solution when applied to a large number of people.
Tim, I just wanted to raise one more thing about prosecutors because you asked earlier, what can we do about it? And I know this is in some ways a terrifying thought because of what's going on right now, but this is an election year and prosecutors are elected. So we can, as activists, remember how they met this moment and take that to the ballot box, whatever the ballot box looks like in November, because that's where we can finally exert some influence over them. So I just want people to keep that in mind.
Well, yeah, I'd just add to that. I've been saying for a long time a couple of things, and I'm hopeful that a law review article I've been working on doing away with some aspects of immunity and allowing for more accountability. But one of the other things I've been saying for quite some time is stop putting prosecutors only on the bench. Because if they haven't had defense attorney experience, I don't want them on the bench. They can have both, and that would be the ideal. I've always said prosecutors should have to be a defense attorney before they're a prosecutor. So, you have some hope of reaching them and they understand the gravity of their decision making. And the other aspect of this is we have placed such a high price on both parties. Republican Democrats have for years wanted to be the tough on crime, and they want to be the one that is going to, have the answers. And we're seeing that if anybody gets out under the coronavirus issue is released, look at the media attention they'll get if they commit another crime. We'll never hear about the 999 that didn't and that are at home and they're trying to contribute to society, but we will hear about the one that was a problem. So I hope we can start to change a lot of that mentality, but if we want our judicial system, our criminal justice system to change, we've got to start changing who become judges and who are prosecutors and what's our ability to hold them accountable for some of the decision making that they are rendering.
If I could just add one more sort of concrete thing that I've been thinking about along these lines in terms of what we can do with prosecutors and their unchecked behavior right now. In terms of local legislation and sort of court rules and the statutes that govern courthouses around the country, one thing is to potentially pursue emergency legislation or emergency rules that flip the burden when it comes to considering pretrial presumptions for detention and release, which are currently very much weighted, generally speaking, to presumption of detention on for certain charges or in various contexts, and flipping it so that prosecutors have to explain themselves and answer for why detention is justified given the grave risk posed right now by incarceration. And so that's just something that advocates that are pursuing non-litigation tools to consider as a thing to try to implement in their rules and statutes locally.
It's a great point. And I do, in terms of the Eighth Amendment analysis and then many states, have, in terms of detention decisions, proportionality is a concept that is very important. And whatever law is out there about proportionality, I think you can throw it out the window at this point, because the analyses had been done under completely different circumstances, when detention didn't have this high likelihood of death that could result from it, where you have this combination of a contagious, potentially deadly disease, particularly to a vulnerable population, and then combined with the absolute scandalous lack of health care. That's just a different sentence than it was before this took place. So I do think, in terms of kind of solutions, that people should think creatively about the law, because the law, to the extent that it is weighing proportions, did it in a completely different context that just doesn't make any sense anymore. Before we move on to the next topic, I did just want to ask if there are any questions. We could pause for questions from the audience.
Hey guys, so there have been a lot of questions. A lot of them I think are going to be covered if you guys keep moving through your topics. So I would like to encourage you to definitely move on to speedy trial questions and concerns, because that we are getting a ton of questions from our audience members. As you know, in certain places like New Jersey and Washington State, they have the courts there have declared already that this time during this COVID emergency is excludable time for speedy trial calculations. So our audience of over 300 people is asking, how do we challenge suspensions or tolling of these things? Is there anything else to be done to try to protect speedy trial rights? Is there some en masse motions that we can file to sort of do something broader for all the clients? Discuss.
All right. And to just kind of lead into that, so the speedy trial right of the Sixth Amendment, and then there's also a Speedy Trial Act in the federal system, as well as many state systems. It essentially demands a speedy trial. I think the federal statutory timeline is 70 days is what you're entitled to go to trial in. And as Shannon mentioned, and as some of the questions have mentioned, there are exclusions for in the ends of justice. But at least in the federal system, that is a very tight standard. I have seen court orders, we've talked about them in prep, about that have purported to find exclusion in the ends of justice to any delays caused by the COVID-19 outbreak. I guess our first question is, are those valid? And the kind of preliminary or kind of follow-on question is, what do you do about them in terms of challenging the lack of a speedy trial right now, when it's impossible to meet with clients, it's impossible to impanel a jury, it's impossible to actually come into the court system? You can push for the speedy trial, but if you actually get the speedy trial, it's likely not to be anywhere near the sort of trial that we've always talked about. So I'll throw it to you first, Premal, because I know you're working on some speedy trial.
Sure. Just to sort of take on the last part of what you said first, I think, in most cases, the most urgent thing is, as we've been sort of harping on, is release. For many, many people who are incarcerated who can be released, and I know April has mentioned some instances where that might be more challenging to seek, that is going to relieve some of the urgency. And some of the, what the case law even talks about is the anxiety of the defendant, right? So I think the first and foremost issue is to push for release. Beyond that, the case law contemplates the anxiety of the defendant, and also the prejudice to the defendant of incarceration in violation of speedy trial rules. And so while they differ from state to state and from jurisdiction to jurisdiction, the sort of general premise, right, is that these things need to be balanced. There are multiple factors that need to be balanced, the reason for the delay, but also very importantly, and important for advocates to be considering, the impact on the defendant. And so when we think in this current moment about the prejudice to the defendant under, for example, the Barker versus Wingo standard, the robust pleadings that have been floating around that talk about the harms of incarceration and the sort of the deadliness of this infection and the risk of transmission, I think are all speedy trial arguments too, and come into using that prong to make the speedy trial argument is really important. you know, I also think that a lot of the case law that addresses reasons for delay, which in this instance, I can imagine, of course, lots of courts and, you know, governing bodies and prosecutors saying, oh, this is COVID-19, right? Done. We don't need to talk about this anymore. It's a national emergency. This is it. We're not talking about this anymore. It's an obvious reason for delay. But really what the courts have contemplated before is more things along the lines of an essential witness couldn't be tracked down, right? Things that are actually related to the litigation and things that would be essential to the litigation. In this instance, release can address some of the concerns, right? Like that's not, the emergency is not one of the things that the courts have generally contemplated as a legitimate reason for the delay of litigation. And so I think pushing back on that assumption that might be untested in lots of places right now is really important.
So I would add to this, what about reversing it? And there's supposed to be a presumption of innocence here. How about dismissing cases when you can't guarantee that someone's going to have their rights that they're entitled to done in a way that is consistent with their constitutional protections? So you can't get a speedy trial because we're going to say it's waived because this is such an extreme circumstance. I think it should be the other way around. We can no longer bring this case because I can't guarantee that somebody is going to be able to have their constitutional rights. I know that's radical, and everybody says, "Oh, you're going to have bad guys are going to be out on the streets, and it's going to be chaos, and it's horrible." If we cannot give constitutionally protected rights to individuals we're accusing of a crime, and we want to take away their liberty, the answer is to continue to take away their liberty. We've lost our damn minds.
And by the way, speaking of Premal's call to advocacy and to shaping the narrative here, prosecutors drop cases all the time for far worse reasons, right? And let's just make that clear that
I had a case once where the prosecutor dropped a murder charge because they had committed such outrageous Brady violations that they didn't want anybody to find out about them, and so they agreed to drop the charges as long as the record in the case was sealed. And from our perspective, I mean, who the hell cares, right? I mean, the client goes home.
That's right. Police and prosecutors drop charges for ass-covering reasons all the time. This should not come as a shock to anybody, and that we would have to do it a little more now is actually more the norm than otherwise.
I wanted to throw it over to April because I know that you talked about speedy hearings in the parole context, and I think that those are different circumstances where, you know, a lot of the time in the parole context, the process that you're going to get in terms of the hearing is quite limited anyway. And so there seems to be a lot less of a downside to speeding that along as there would be in the trial context. I mean, I'm not sure any of us, I think Brett is exactly right. The balance ought to be in favor of release when you've got a presumptively innocent client. But if the balance isn't that, I'm not sure a lot of us would say, okay, let's just go to trial without being able to investigate, being able to talk to our client, without being able to have a real jury. In the parole context, I think the calculus is a lot different. Are you having any luck, or are you hearing about people who are having luck with getting speedy parole hearings or quick dismissals because there isn't any evidence?
Yeah, so, you know, I don't have an update on actual dismissals. I think with the parole revocation context, absolutely. The burden is preponderance of the evidence, is hearsay is allowed. Your rights are already so limited in that context. But I do want to say there's another type of parole hearing, a parole grant hearing. So think about the people who are up for parole grant hearings who their rights may be limited because the parole hearing officers are not able to go into the facility. So yes, from the standpoint of revoking someone's parole and taking away the liberty is probably some benefits to delaying. But from the standpoint of looking at people who are impacted with a delay of release or delay of their rights because they don't have access to a parole hearing.
I think that's a really important point, is that for some of these, for some, I think the remedy to push for is dismissal in the pretrial context. In the post-trial context, it may just be, you know, give me my hearing, because you're really not going to get much better process in the old world as you will in the new world. So you might as well get the hearing quickly, especially for a grant. So it's a great point. One thing I did want to kind of throw out there, I know if I were defending these cases right now, And I looked at the Zedner case from 2006, which I think was Justice Alito's first opinion. As I understand it, the Speedy Trial Act under the federal system requires an individualized determination. And I agree with Premal that just a mass threat to the justice system, in Brett's words, we can't provide justice, so therefore you sit in jail, is likely not going to be a good enough reason in any event. But I think one other aspect of Zedner is that it requires an individualized determination in each case. And so these mass orders that say, we're going to count as in the ends of justice all of the time spent delaying the trial due to COVID-19 as excluded from the Speedy Trial Act calculation are very vulnerable in my view. And so I know I would wait 70 days, and then on day 71, I'd move to dismiss for lack of compliance under the Speedy Trial Act under Zedner, because I'm not convinced that those exclusions are valid. And to the extent that you've got a bunch of district courts, at least in the federal system, assuming that they are, I'd wait for the time to run out before I brought the motion, but then I'd bring the motion on the 71st day.
Yeah, I completely agree with that. And I also just wanted to add another thought, sort of piggybacking on what Brett and others were saying about the presumption of innocence and sort of other rights, right? Figuring out being creative about all of the constitutional rights that are implicated within the speedy trial issue. For example, in lots of places, counsel doesn't even get appointed until after an indictment has been filed or a charge has been brought. And so someone could potentially be sitting in pretrial detention for months, weeks or months, without even having counsel to seek their release in the midst of this pandemic. And so thinking about the intersection of the other rights, the right to counsel, the right of access to the court, right, all of these other pieces that are also implicated in the length of pretrial detention before one has their trial or their charge brought, I think is a really important piece of this.
Yeah, and I think you brought up, go ahead.
Oh, I was just going to say, one of those being the right to an individualized determination of bail. It's kind of the corollary to the individualized speedy trial assessment.
Right. I think that and Premal also raised the lack of good investigation during that time frame, and I think April talked about it earlier. We were talking about it on the defense side, but you do have this problem on the prosecution side, where the grand juries are not sitting right now. So no grand jury subpoenas. Police officers are not doing the same sorts, I would suspect, and I think that I've heard anecdotally this is true, that police officers are not doing the same sorts of investigations that they would normally do. They're not going out and interviewing witnesses at the same rate as the defense investigators are either. And so if you combine that lack of investigation with what Brett talked about earlier, is that prosecutors have really good win rates, often regardless of what the level of the evidence is, are we going to start seeing charges brought now on even shoddier evidence? That is because we've got a system that is kind of hampered on both sides in some sense in terms of investigation. When we do start seeing these charges, are they going to be weaker? And and even with weaker charges, are we going to still lose the same number of cases? Are juries still going to say, well, we know it's reasonable doubt, but we're kind of a little scared that there might be something here and convict, as we have seen them do in the past? Yeah,
I'm very concerned that we're going to have, unusual decision making going forward and unorthodox and inconsistent. Just recently, we had in Utah, the governor has put in place a voluntary stay-at-home order, and the Salt Lake, the mayor came out with an edict that violating the voluntary stay at home now is a criminal misdemeanor and punishable by a $2,000 fine and a year in jail. And I thought, wow, so now we have this standard of a voluntary, very flexible, make good decisions when you go out of your house, to a sitting mayor saying, hey, but if you do violate this, where the standard is difficult to decide who's doing what and what their motivation is, it's going to be criminal. So we're going the other way in some areas and on some issues.
You'd have help on a due process vagueness challenge if you wanted one there, Brett.
We're going to come to the ACLU for sure on that, but I think they've already got it on their radar.
Good.
Thank
Yeah,
you.
I mean, I think the ACLU has been very active. I saw yesterday the DC branch of the ACLU worked with PDS in filing a challenge to all misdemeanor sentences in DC. And you know, the DC judges, they certainly haven't been perfect on this, but the chief judge has actually, you know, here in DC has instituted some guidelines for release that are better than they are in a bunch of other jurisdictions. So I think that you found a good forum for that sort of lawsuit here, because I think hopefully we've got a pretty good bench and a really bad jail. And so I think that combination, it might result in some good precedent here, but it's obviously still early.
I think that's right. And I think like so much of the work that folks on this call are doing, the lawsuit might win, but more likely it'll bring folks to the table in good faith, all of us in this together, trying to figure out the most sensible way to protect everybody, like Premal has been saying, not just folks who are inside, folks on the outside, the outlying communities. And that's what this is about. Like we can all bring our pet projects into this, but right now we're addressing a crisis and all of us want to stop the spread, all of us. I hope that's clear, you know?
Yeah. And I think, you know, April made the point that even if these don't succeed, it shines light on a system that has some real flaws, healthcare flaws, racial disproportionality flaws, like those sort of issues get highlighted when you challenge these decisions, even if you don't win, because ultimately, at least right now, the reality is clearly on the side of those challenging incarceration, the side of those talking about the real catastrophic consequences. And so, you know, whether it wins in this particular case, it will win eventually. Go ahead, April.
Hi, and I also want to encourage, like when we think about if it's any positive that can come out of it. I know we have some researchers on the call. So we've been talking about it in NLADA, how can we track the data, right? When we do have jurisdictions who do the right thing and they release people who should not have been held to begin with, how can we actually show the overreaching of the system? So I would really encourage our community to really think about strategically how we can partner. If you don't have the capacity in-house to track your data and do research, to be thinking about partners. So to show that the 700 or 1,000 people that was released in the community, they did come back to court and they did well in the community. And so we have a platform for a policy reform argument when the legislature opens back up, right? So really thinking creatively about how can we work with researchers, how can we track the data, because hopefully what it's going to show is what many of us already know, that our clients don't create public safety risks. They shouldn't be incarcerated. It's other ways to resolve these issues in our society. And so I would encourage people to really be thinking about how can you measure the good news that hopefully will come from some of this.
Yeah, that's another great point. And I know that after this call is done, that Shannon was planning to collect resources like NLADA and some of the other great ones that are out there and send kind of an email to everyone on the call that basically talks about all the great work that's being done out in the community to kind of make sure that whatever happens, these circumstances are remembered, and what all of these prophecies, when they come true, we've kind of shown that they've come true, and we remember who got it right and who didn't, and bring some accountability, as Brett was talking about before, to some of the decision makers on this. So we talked a lot about speedy trials. Another element of due process and the Sixth Amendment is public trials. So one of the items in the Stimulus Act, the CARES Act, was increased use of video and telephonic hearings in court. And I thought that the CARES Act was pretty surgical about it, in the sense that it was only through the consent of the defendant that was allowed. And I think that was, you know, given the haste with which that was put together, I was very comforted by that protection. That said, you know, the Constitution also requires a public hearing. And so I think that we're going to have to do a lot of thinking, just apart from the CARES Act, about what these sorts of video and telephonic conferences mean in terms of the public access to the courts. Has anybody really thought about that? Are people challenging that out there? Has anybody had luck dialing into one of these Zoom district court calls and just saying, hey, I'm here to watch from the public?
I think this is a huge concern. I mean, I think because, you know, it's a concern for people who are charged in the criminal system, of course. I mean, they have rights that attach upon being placed in that situation. It's also a right, though, that attaches for lots of other folks. Like there's First Amendment rights to be able to access jury selection, right, for reporters or for the public. There's a community-wide need for access to what's happening in the criminal system, and for people who are impacted by it to be able to ensure that there's no secrecy or sort of behind the scenes stuff happening in their cases. And so I think it's a real concern. Right now, we don't have juries sitting in so many cases, right? We don't have hearings happening where people could walk into a courtroom. And so I think, Tim, what you just described is that there are Zoom calls that you need a link to access, and there are phones potentially where you could call in. You know, I'd love to hear stories if people have done that, what that's been like. But, you know, I think this is it's a problem now in this immediate triage period after this sort of outbreak has really hit, but it's gonna keep being a problem for a long time. And so really strategizing ways for people to be able to advocate for their clients, but also to incorporate this into the panoply of other rights that are implicated, right? I think that's an important piece here always, is just thinking about the intersections and how this is implicated in all of the other things we're talking about that might be more obvious fights, speedy trial, right? Immediate release, the attorney-client relationship. All of these other rights are also implicated in those things.
Does anybody have a concern that when this is all over, that the courts are going to say, you know, I really like this idea that I don't have to actually go get out on the bench. I just sit on the phone in my office and take my computer up, or I sit in my house, wherever it is, and basically don't ever have to see the courthouse again. Does anybody worry that that is going to become something that judges get used to and really start to try and justify a lot more vigorously than they used to before this became the norm?
Well, I'm actually relieved that I might not have to do as much travel going forward, but that's just on my non-criminal justice clients. I think we've learned that we don't have to be in person for everything. But with the criminal justice system, it's so entirely different, and you're about to put on the line someone's liberty and possibly their life. And if we're going to be, if this is a temporary situation, then I think I go back to what we argued before, which is, you know, presumption of innocence should be the thing that carries the day, and we should not want, as a prosecutor, to risk sending someone to prison where they might pick up this disease and die when they're not, you know, facing a death sentence otherwise. Or even if they are, that it's you know, we have to be concerned. But if this is going to last a little longer than we expect, we better really come up with some great alternatives, because the answer is certainly not for the criminal justice system to be on hold and to not prosecute any cases. But it's going to take a lot more, and I think the judges need to weigh in. And I know all the judges I know, they hate being on the bench. That's their least favorite, which is ironic because that is their job to be on the bench. But now I can't even imagine what's going to happen.
Right. And Tim, I just wanted to weigh in. It's interesting because I think I was at an American Bar Association meeting, and we were talking about technology and how it's changing the legal system. So it was already conversations taking place about the use of technology. But I didn't hear it from judges saying they don't want to be on the bench. But we talked about how the hardship that it may be for many people who don't have resources to come down to the courthouse for a status hearing and to spend the entire day just to say your case is reset for the next 6 weeks, right? Like, how can we reduce that burden on our clients, specifically communities that already don't have resources? So I would say, to kind of flip it on its head for those who represent indigent clients, to really be thinking through how can you prove, and even those arrest warrants that many of our clients get simply because they can't show up because they may have forgotten a date or don't have the resources to get there, to really think through, is it a possibility that we could reduce some of this, I would say, abuse of the system and overwhelming our clients' lives when they come into contact with it? So just something to think about from our lens as defense attorneys.
No, it's a great point, April. I mean, it does. There are a lot of hearings that really don't require in-person presence and travel and the all of the resources that are required to do that sometimes, and then just the time and energy. So I do take some comfort in the fact that the Supreme Court shut down in 1918 for the Spanish flu, and I haven't heard of any real consequences out of that. I mean, it could wind up being that we don't change the system fundamentally because we were shut down for a little while, and maybe we use the time to get things better in terms of striking the balance between in court and out of court. Premal, I know you wanted to say something.
I just wanted to, I think that's a really great point. And I think, figuring out exactly what you just said and how to balance that with something I've been seeing a lot in the work that I've been doing the last few weeks is the sort of the deep anxiety of the family and friends of people who are incarcerated, right? And figuring out how do they get access to information. And I think that those two things seem like the important things to balance, right? In addition to the person who's actually arrested and charged needs and rights. And so figuring out ways that there can be public access to information and also minimizing unnecessary burdens, the onerous burdens of sort of travel to court for people seems really critical. And I think engaging the community, for public defenders and all other advocates to sort of like be engaging the community as a really active partner in a lot of this advocacy is one way to be able to more strongly push for access to information about what's going on in the system.
Yeah, and the courts can adapt. Just real quick, Somil, because I know you were going to jump in, but the courts can adapt. I mean, I think the appellate courts have gotten much better by broadcasting oral arguments and allowing the public to actually attend. And, calls like this one show that you can have, some sort of panel that is one proceeding, and it can be watched by hundreds of people who are just there as spectators as in court. So it really is, it actually could improve public access, but I'm not sure that anybody is really thinking through those sorts of issues right now. And so the worry is that they'll just kind of develop this process that excludes the public.
I was going to say something exactly along those lines, and this could be a place for public-private partnership, right? If there are anyone from Google on the call, I doubt it. You probably have other things going on, but if there are, this is where tech can make life easier for a lot of people. And Zoom is fine for now, but if we can improve on Zoom, that and expand access, particularly as April said, to people who may not have access to a laptop, but could still somehow dial in or video into proceedings. I mean, if they're going to force defendants to testify remotely, then we should never have another material witness warrant again, right? I mean, that's a real improvement on the criminal justice system if we can get witnesses to testify remotely as well. So that's just one silver lining to add on top of everything that people are saying.
Although let's actually dig down a little bit on that. I know that when you talked about witnesses testified remotely, I could see Premal saying confrontation. What about confrontation? So what about confrontation, Premal?
Yeah, no, my poker face isn't great. Yes, it raised some red flags for me right away. I worry a lot about video and the normalizing, as someone said earlier, the danger of normalizing a lot of what's happening now in this triage moment into things that could be sustainable. And I think we need to be really careful and really thoughtful about what is actually good and what's really dangerous. And I think the use of video and technology carries a couple of very, very dangerous elements. One is it can eviscerate the right to confront the witnesses against you, right? There's no way, just as we were talking about the attorney-client relationship earlier, there's just no way to do it right, to actually, have the sort of body language and nonverbal cues and to sort of read your witness and for the witness to be able to read everybody else. There's no way for that to happen effectively on a video or a telephone or anything else. And so that's a fundamental concern. And this is sort of a side concern, but it's really important to a lot of people. In a lot of places, a lot of this technology is for profit, and it's not free. And so we got to be really careful when we're talking about the benefits of technology in the criminal system, that we don't go down that very slippery slope. And currently there are lots of people in the country who are having to pay to even find out what's happening to the health of their loved one who's incarcerated.
Of course, and to say nothing of the privacy concerns and the surveillance and hacking concerns, no question.
Yeah.
Right. That is, I mean, that from what I understand, I mean, Zoom has grown exponentially, like the virus has, almost along with the virus. And whether it has the infrastructure to protect, recordings of conversations and to protect all of the new subscribers that it's got, and I don't mean to single out Zoom in particular, but I mean, I do think that the technology creates that sort of issue. And with the courts, I think April's concern is hugely important. I mean, if you're going to have access to the public, and it's going to depend, it can be made a lot better because people don't have to travel and they could attend hearings that they wouldn't otherwise see. The loved ones could find out information about one of their close relatives who is in trouble with the court system or is involved in the court system, but only if you make sure that everybody has some way of meaningfully accessing it, not if it's just, if it becomes the only way that you can see a court hearing is if you have, internet and a laptop and the ability to get in that way.
Can you imagine being a defendant in a case and going all the way through the criminal justice system and not have interacted with a live person and then being convicted and then put into prison? Or can you imagine being a prosecutor and making decisions? We already have, I've always been, used the analogy that prosecutors, they never really understand who they're prosecuting because they're more like a surgeon. They come in, they're scrubbed in, they perform the surgery and they leave, and they don't ever really get to know. They're not like the practicing, family doctor that gets to know the family that they're coming in. And I can't imagine anything more disconnecting and making that problem worse, detaching prosecutors from the actual humanity of their job. I worry about that. I think there are, great benefits. I don't know if we've turned a corner and we're never going to go back, like, some things that occurred after 9/11. But I do worry about that and the impact of a criminal justice system that is already struggling to maintain its connection to, the humanness of the system.
Yeah, I mean, it really is a balance. On the one hand, it would be nice if technology could relieve, some of the status hearings that people have to come in for 4 hours and travel in and take time off work for, only for the judge to say, so what's happening? And then they hear what's happening, which they could have known from looking at the docket, and then they call the next case. Like, if technology can stop that, it'll actually help courts do what they should do. But if it means that, and that is just such a nightmare scenario that you talk about, Brett, where, you have somebody who goes through the entire criminal justice system without ever actually interacting with anybody except the people that they're interacting with at the jail, that would be a real problem, even if they can have, video calls in the meantime.
So has Kafka arrived?
And I mean, let's keep in mind that in a system where 97% of people plead out, that's a real possibility for the vast majority of people.
Right.
Well,
and now that you raised it, Somil, I mean, one of the things in the CARES Act is that plea hearings now can take place remotely. So it is by consent of the defense, but since there is no discussion of public access, you can have an entire plea proceeding that takes place completely remotely and without the public ever knowing that it took place, except presumably if the case is unsealed, it appears on the docket. But otherwise, there's just no record of it other than the video calls.
And this is exactly a place where we can flip the burden, as Brett said, right? Prosecution, what did you do to ensure that this plea was taken with the consequences of COVID in mind? And what non-incarceral alternatives did you explore? The burden of a prosecution that passes due process muster has always been on the prosecution. We've just never made it that way because we have this rote colloquy with the defense. Maybe this is a time where we actually put it back on the prosecution where it belonged all along.
And I do think that to April's point, I'm not sure that was necessarily a provision that was designed to be weighted against the defendant. That is, there's a lot of time where once you enter the plea, you wind up getting out. And so you have people waiting in jail, knowing that if they were to enter a plea bargain, they could get out, and they want to enter the plea. And right now, with the court shut and potentially not allowing them to do it, I think that was a potential option that was probably viewed by some as defense friendly. And in right circumstances, it is. The worry is that the scales will now be weighted, where you're told, enter a plea by video and you can get out, refuse to enter a plea and you're going to sit in and you can wait for your trial. And by the way, there aren't any trials happening now, so you're going to be here a while.
So are we just going to increase the trial penalty then?
Yeah.
by so doing?
Right, because I was going to also say, Tim, in a lot of those jurisdictions, not only can you wait for a trial, but you can also wait for assignment of counsel.
Yep.
So we have to remember, in a lot of places, arraignment court is a plea meal. So if you have to decide between taking a plea and getting out, imagine what the outcome will be. And I think it was actually taking place in Cincinnati, Ohio. Like, their response to releasing people was to plead them out and to put the stamp of a criminal conviction on people in order for them to secure their release. So if you have to decide between a conviction and protecting your health, you know what's going to happen. So in a lot of places, these cases are not being dismissed or people being released. It is a plea meal just to clear the jails. And we have to remember that.
I mean, the trial penalty in those circumstances, at least for some people, becomes the death penalty.
And by the way, there are courts right now, arraignment courts, bond courts in Florida, in Oklahoma, elsewhere, where this is happening. I mean, folks appear on video from the remote jail, speak to a judge when the point is ostensibly to get a probable cause hearing, but in fact, the judge says, well, you could get out right now, and they do it, and they never see anybody. So this is reality in a lot of places in America already.
And even when you do have, sorry, I was just going to say, even when you do have counsel appointed, you're not able to do the plea together or to really meaningfully talk about the plea. I mean, this is right. It's a problem on sort of at every level.
Yeah, I mean, it really does become very difficult. You talked about the lawyer-client relationship. I think some of the hardest conversations that I've ever had with clients related to the plea.
Right.
And it's usually not one conversation, it's hours and hours of conversations that are usually after we've already built up some kind of meaningful relationship in person. I do think, the huge incentive to plea right now, combined with the lack of any real relationships, I think it's very hard to provide and certainly receive meaningful advice when you don't have a real, in-person actual relationship with your counsel is makes it very hard to talk about what pleas mean in this environment.
Yeah.
I wanted to weigh in that there are a number of folks who are also adding in other important issues, such as the issue of if we all move to this new Zoom video conferencing world, what kind of accommodations, if any, are being made for people with disabilities in order for them to actually meaningfully access and participate in those things. We have questions about, interpreters who aren't getting going and visiting jail cells, and so even if there is a defendant who can make a call out to their lawyer, or a lawyer who can make it in to visit through a screen or through a telephone or through a window to talk to their client, that there aren't any interpreters there to help them do this. And so I know that not everybody here has answers to these things, but there are questions and concerns that continue to be raised that that none of us have much hope, I think, to answer this.
Thank you. I think those are really important questions, because we're talking about like access and due process challenges for maybe what we consider the majority of clients, but what about clients or advocates and other people who support this work who have disabilities, or and I think it's really important to note as well, how are we monitoring the clients that's already incarcerated and who may be serving long sentences, who may be hearing impaired, or how do you communicate with clients who have disabilities who are incarcerated to check on them and to make sure they're okay? It's such a complicated issue just for clients, period. But then when you add on to it all of the myriad of issues that come with speaking different languages, having different disabilities, this is it's really overwhelming when you think about how many voices that we're not even covering, or different communities that are not even getting attention at this time.
And speaking of that, we actually have another community that people are asking about. Is anyone aware of any differences between the what's happening in the world with juveniles as opposed to adult detentions? Are there significant differences that you want to discuss, or is it too soon to sort of start noticing any of those?
So I definitely, I was a juvenile defender for 2 years in Shelby County. And one thing that came to mind was that just like here in DC, a lot of our clients who are youth or children who are in the system, their release is predicated on very subjective programming decisions for them to, quote, be rehabilitated in order to be released. And like here in DC, PDS is in the facility, right? Protecting those rights, making sure their rights are not being violated while they're incarcerated. Now, when you remove those advocates from the facility, or remove those attorneys who are working with clients who are post-adjudication in the juvenile system, I'm not sure who's watching and who's paying attention to the impact that this is going to have on incarcerated children.
And it shouldn't be a surprise to any of you panelists that we've gotten probably dozens of comments that perhaps someone should consider filing ethics or bar complaints against prosecutors who are behaving in less than humane ways to COVID-19. Anybody want to respond to those?
Well, the one thing I do want to say is, my world is primarily the federal side, and just remember that most bars across the country do not have any real ability to impact federal prosecutors, and they defer to the Office of Professional Responsibility. And, it was interesting, while I was U.S. Attorney, I interacted a lot more with, obviously, the Department of Justice, and you would get just remarkable responses. If a defense attorney ever raised an OPR issue or wanted an OPR investigation, that was almost the certain death knell of any inquiry, is if it was raised by a defense attorney. So in the world of keeping a prosecutor in line, the defendant is very prejudiced.
So, Neil, people are also asking about ICE detentions.
Yeah.
Any news in that realm that you could share with folks on the call?
Yes. So individual cases in individual jurisdictions are being filed around the country, and some of them have been successful. They're gonna flow from the same sorts of arguments as habeas petitions and other ones in criminal courts, right? This is about conditions of confinement. So that's, I hope, encouraging, because you can sort of templatize these actions. And if you can find a facility and find a lawyer and find a client, then you could probably bring one of these. So that's sort of been our goal, to get a few in the door and then fan out across the country. But of course, immigration detainees are some of the most vulnerable folks who are being who are facing this down, and their sort of conditions for release, even if they do get out, are much more precarious than others. So I want to front that absolutely. But yes, there is work being done. If anyone, and I mean, this is sort of a generalized comment as we close, if anyone wants to brainstorm or has a particular facility that they believe is in need of this kind of systemic treatment, reach out.
And how did they reach you, Somil?
My email, I can give it right now, is strivedi@aclu.org. One more time, that's strivedi@aclu.org, and we'll find something for you.
Thank you. And look, there have been a lot of very specific questions with people who are participating as audience members asking for motions, asking for specific argument help, asking for specific resources. And I wanted to let them know that actually after this call, in about an hour, we're going to send an email to everyone who participated. And we've gathered a number of resources. Those are from all sorts of great organizations like those represented on this call and those who aren't. Who are gathering things, who are tracking numbers of cases, who are tracking releases, who are tracking the court orders, all of these questions that people have asking if anybody's keeping track of all this. The answer is yes, there's some really amazing work being done by a lot of organizations. And so we have links to those tracking things. We also have links to motions banks, et cetera. So the National Association of Criminal Defense Lawyers is one of these groups who is gathering specific motions that have won, or judgments or court cases. So we have a link to their great website. Lots of people with lots of resources and lots of practical help. And if you are someone on the call who is gathering that kind of info and you think that maybe I don't know about your resources, please shoot me an email immediately after this call so that I can include your resource in that email that I'm going to send to everybody in about an hour. Because I know that people are desperate for help and need some specific guidance, and the defense community is really coming together in a variety of places and providing this sort of help to people. So Tim, I don't know if you want to give everybody just a last couple of seconds to say anything.
Yeah, why don't we go one time around, starting with April and moving to Premal and then to Brett and then to Somil, and give everybody the last word.
Great, thank you. Because like many people who are working from home, my two little ones are about to probably bombard my background in a few minutes. But I do want to bring up the issue of, can you pause that? Self-care and compassion fatigue, because I know many of us were out here thinking about the clients and the populations that's directly impacted, but compassion fatigue is real. So one thing that we're doing at NLADA, and hopefully it's other resources in the community, to really be support groups for advocates who are on the front line, people who are fielding the phone calls every day from clients and hearing about these awful stories, and themselves having to come home to possibly family members who work in the healthcare systems and other systems that's impacted. It's a real issue around self-care. So my closing note would be to remind everyone to take care of yourself and to take care of each other. And at NLADA, we'll be offering defender support groups, so you can look out on our website for that, in addition to the substantive motions and other resources you need to get the work done. So just take care of yourself.
Thank you so much, April. Premal.
Thanks, April. That was great. That my anxiety went down just even listening to you talk. I know everyone's is really high. So at the Defender Impact Initiative, one of the things we've been doing is working a lot directly with defenders to do a lot of the brainstorming around arguments. Like I was talking a lot about sort of thinking through the intersection of different constitutional arguments, right? And where you can be creative and come up with how do these other 5 arguments, wrap into this one argument that I'm making that's the most obvious or one at the forefront. And so I'm happy to brainstorm with anyone out there as they're thinking through the best sort of talking points or points to make in their advocacy on behalf of individual people. And then the other thing that we've been doing a lot of is figuring out ways to then amplify those points into non-litigation strategies with coalitions, community coalitions, pushes to make court rule changes and things like that. But specifically drawing on the work that public defenders are doing on the front lines. So I would be happy to talk to anyone about any of those things. I encourage the same self-care that April just advocated for, and thank you all very much for joining us.
Thanks, Premal. Brett, last words.
Well, thanks everyone for the opportunity to be on here, and really appreciate Tim and Shanna and just this opportunity to get together. There are a couple of ways that I really would ask for folks to get vocal. I think the White House needs to hear from people, and continual pressure needs to be applied to our legislatures across the country. And specifics need to be raised that there are individuals in both the federal and state systems that are vulnerable, they're elderly, they're sick, they're going to be the ones that may contract the coronavirus, and it will spread, and the reports from inmates and their families about the conditions and what's being told to them are real, and we need to make sure that pressure is applied. There's a couple of pieces of legislation right now that are very, very important. One is an incentive piece that is being drafted in the House, being led by Democrats, but Republicans are pushing for it as well, that will incentivize facilities across the country to consider their populations and to release them in anticipation of rampant infection. And there's also provision in the Senate right now that is stalled, and it's really being held up by 3 senators, Senator Hawley, Senator Blackburn, and Senator Kennedy. So if those are your senators, the provision is the elderly and compassionate release provision that needs to go through, and that's, I believe it's 4018. Reach out to your representatives, apply pressure. We should be coming together as a country. I'm going to remain optimistic, but I'm going to be very reluctant to give my trust until I start to see some real good decisions being made.
All right, thank you, Brett. Somil, final words.
Yeah, I want to piggyback on Brett's optimism. Look, 9/11 has been invoked a couple times today. And look, 19 years ago, reformers like folks on this call could have told you to a mortal certainty that the war on terror would result in the curtailing of due process rights. And we were correct, and nobody listened, right? This time, I'm not saying everyone's listening, but the fact that there are 500 people on the phone right now while you're holed up at your house, fending off your children, is a real sign of hope. And I think we are making an impact, and folks are getting released, and conduct is changing. Not on the scale we want to see. It doesn't mean we take our foot off the gas, but it means we have a chance. And so I just want to say thank you to everybody on this call who is taking time out of their day to figure out how to fight the fight, and hope that you remain optimistic, because I remain optimistic, and we are here to help.
All right. Well, if a contagious disease can't remind us of our humanity, I don't know what can. I want to echo April's self-care message and encourage everyone to stay safe and stay healthy. And thanks a lot to our panel, which I thought was wonderful. And thanks to the audience for joining the call. Lots of great questions, and we'll talk to you again sometime soon.
Thank you, everybody. Thank you so much for your time. And we will be making a recording of this available as soon as we possibly can, in case some of you missed it. Thank you for being on the front lines. Thank you for continuing to care about other people as you also take care of yourselves. And I think the point Somil has made is a good one. I'm sure many of you saw that the Department of Justice immediately raced to take advantage of this opportunity and say, oh wait, we just need to suspend habeas corpus for all. And that message didn't go over that well. There were reporters who have been educated over the last 10, 15 years since 9/11 about due process rights, about criminal justice reform issues. They got a lot of pushback, and they ran back for the hills, which is not, of course, what happened after 9/11. Those various federal agencies came forth and said, hey, we need fewer warrants and fewer things in our way, and they got what they wanted. So I do think that we, as the watchers, those of us who are panelists and everyone on this call, has a very important role to play here, and I think we're playing it. And I know that we all might feel like we're not doing enough, but we are, and we will continue to do so. So stay safe and take care of yourself so we can fight again tomorrow.